Docket 114554, State of Kansas versus Daniel Perez.
Good morning. I'm Michelle Davis, and I'm appearing on behalf of the appellant, Daniel Perez, and may I please reserve 2 minutes for rebuttal?
2 minutes is reserved.
In 2003, in Sedgwick County, Kansas, the death of Patricia Hughes was ruled an accidental drowning. Patricia was found in a pool in her residence, which where several other people also lived, including the defendant, appellant Mr. Perez. And then in 2011, the state prosecuted Mr. Perez for the crime of intentionally killing Patricia. And their motive for his action was money. He had benefited from life insurance proceeds because of Patricia's death. And to prove its case, the state presented evidence of deaths of other acquaintances of Mr. Perez that also appeared to be accidental, or Mr. Perez, the state claimed, had also benefited from life insurance proceeds. And in fact, the state also presented evidence that Mr. Perez had actually staged his own death to avoid an earlier prosecution. And so the district court admitted evidence of all of these uncharged crimes, and the district court labeled that they were part of the MO, the mode of operation. And that was the reason that the district court admitted the evidence. There was a pretrial hearing on this that was pretty extensive. The state also convicted Mr. Perez of sex crimes and also introduced evidence of other uncharged sex crimes in order to show propensity. And so we raised several issues in our brief, and the issue I'd like to focus on is the defense requested an instruction on the crime of assisting suicide based upon the evidence that Patricia had intended to kill herself. And so the first question that this court would need to address is whether, and it's a legal question, is whether the crime of assisting suicide is a lesser included offense of premeditated murder. And in our brief, we argue that it is a lesser included offense because it would be a lesser degree of homicide.
Explain
How's it
that.
a homicide?
Yeah, I guess we both have the same question. Go ahead.
And I'm going to have to give you a long answer to that. I think if you distinguish here between, what's the difference between, in the case law on this, that the state cites in its brief, the difference between assisting suicide and murder would be who's actually doing the act. And the state claims that with a suicide, it's the deceased who's actually committing the act that's lethal, versus with a murder, it would be the defendant who's actually committing the act, and that's how you distinguish between the two. So if you keep following that line of logic, it's really then a fact question as to the extent of who actually caused the death, especially in cases where you may have a joint participation situation. That's really then a factual question for a jury, causation. And so from that point of view, it goes along of who's responsible for this killing. We have a killing, we have a homicide, and what's the level of culpability? And even you could even look at it in terms of the legislature passing a law of assisting suicide similar to manslaughter as being a mitigation. And you'll notice if you look at the cases the state cites in its brief, in many other states, assisting suicide is categorized as manslaughter. It's a form of manslaughter. Because for that logic is that it's a mitigating situation.
But it is not so categorized in Kansas. And as you get to the end of your causal relationship, you're still back to the fact that you don't have the defendant as the actor taking the life. And can't our legislature make that distinction?
Well, that's what the case law says, trying to distinguish between the two. And
But we can have aiding and abetting, premeditated murder, capital murder, any kind of murder. You're assisting someone else to commit the act.
right.
So, but it's not the person themselves.
Or even felony murder, where there's a death and you're prosecuting someone for that even though they didn't commit the act.
But we
They're
still have
still
to get
criminally responsible.
we still have to get over the fact that it's the victim is the actor.
Right, but, I guess the only other part that I would add, well, and then again, that's a fact question. I mean, that's why it's a lesser included offense, because, it's a fact question for the jury, and again, I
Well,
think.
I'm
I'm
still
not,
not
I'm
clear
not
how you.
explaining this very clearly.
Go ahead.
Again, it's a causation question. And so the reason for it to be a lesser included offense would be a situation at trial where there is a question here of who caused the death and what the evidence is going to support. And so as a lesser, it's giving the jury an option of saying, this is your defense, that you were only simply assisting a suicide. The state's claim this is murder. And somewhere in that factual spectrum, the jury has to fall. So that's why it's a lesser degree, because it's saying instead of actually doing the act, you assisted or you aided. And I need to get into that because the current statute says participated in a physical act by which another commits suicide. So again, the current statute is talking about you're participating. You may not have, and again, this court has to interpret this statute. I'm not sure it has been, because the Cobb case was interpreting a previous statute where it was about assisting. Our current statute is participated in a physical act by which another commits suicide. So again, it's that what's the extent of your participation? Were you the direct performer of the actual act, or did you participate where someone else was the direct performer? So again, the defendant's still involved.
Do you think all the elements of assisted suicide are present in the crime of first-degree premeditated murder?
Well, no.
And isn't that how we decide whether or not something's a lesser included?
Well, that's one way to do it. I mean, there's several ways under the statute. One of them is a lesser degree. I didn't try to argue the other way under the statute.
Okay.
I only argued the lesser degree.
So you're not relying on sort of an elements test?
No. Oh, no. And then the only other argument I would make is it's in the statutes right after murder, manslaughter, involuntary manslaughter, I believe, and then it's assisted suicide. And it's in the crimes against persons area under the statute. So again, it seems to follow this kind of sequence.
Well, assuming we follow and adopt the legal analysis here that it's some form of a lesser degree, what are the facts that you're relying on here that there's evidence that the victim committed suicide?
Well, that's again a long answer, but if you look at the Cobb case where it talks about assisting, and then the state claims in its brief those cases are all statutes from other states where the crime is defined as aiding, and versus now it's talking about knowingly participate in a physical act. So there's evidence in this case because there weren't any eyewitnesses. The evidence from EH was that Patricia and Mr. Perez had talked about the fact that Patricia was going to die.
There's evidence because there weren't eyewitnesses.
Well, yeah, we don't know exactly what happened.
All right.
And so what we have is EH telling us about this planning ahead of time. And she testified that Mr. Perez was there, that she left the pool, and Mr. Perez was there with Patricia. And then, so there was the evidence of that. And then the coroner at the time of Patricia's death, because there was also a coroner that the state brought in later who had independently reviewed at the time of the trial. But the coroner at the time of the death said that there were no injuries to indicate a struggle, no defensive wounds. And the coroner, in fact, even had suggested that you can't commit suicide by drowning yourself. So that was planted in there for the jury's minds. And so again, but it sort of depends on, under the old cases where you had assisting or aiding, they distinguish between, it's assisting suicide is where you provide the means of the other person committing suicide, and active participation or involvement precluded a finding of assisting suicide. And with the statute now including participating, I don't think you can draw that line where participation or involvement of the defendant precludes an assisted suicide conviction, because our statute talks about that a defendant is broader. A defendant's culpable if they knowingly participate. And so I think you have to read the culpability for that crime broader, because the language in the statute's broader.
Would the verdict of premeditated first-degree murder kind of how if the jury thought that the victim committed suicide, would they have convicted him of first-degree murder?
Well, again, it's just the argument that they didn't have any other choice and that they felt he was criminally culpable. Again, the argument is just premised on the fact that if they had been given a choice and been able to consider that possibility, if you don't instruct the jury on that crime, then they don't really consider that theory, would be our argument.
So the you made some mention about it being like mitigation. So to understand that, the mitigation is the victim's own intent.
And, right,
So is,
the mitigation would be because it's a lower severity level, and then that you're participating. And again, it's the level of your culpability, the extent of your actions.
So if the
Would be
victim
the
wanted to
mitigation.
die, you're less culpable for helping them.
Well, the difference is between the first-degree murder is you're intentionally killing somebody, versus with the assisting suicide, you're participating in a physical act by which another person kills themselves.
except you still intend to kill them.
Well, right, because it talks about with intent to assist another to commit suicide. You knowingly participate. So again, it would be the extent of your actions would be the mitigation, the scope of your actions. And there's also some cases which talk about, sort of joint suicide sort of situations where one person survives and that they're still culpable, they're still criminally responsible. And so it could potentially also cover that situation. So that concludes my comments on that issue. I did just want to briefly just mention on the other issue, which was the hearsay issue, and all the evidence that came in that was hearsay regarding other actions by Mr. Perez. And the district court had admitted that evidence to show plan, mode of operation. So I think it's a little difficult for the state to now argue, and it's inconsistent with the district court's ruling, where the district court said this evidence is not hearsay because it's not being admitted for the truth of the matter. Well, if you're going to admit that evidence to show a mode of operation, then you can't say it's not being admitted for the truth of the matter. I mean, those are just too inconsistent. And so for that reason, the district court erred in admitting the evidence and saying it wasn't hearsay. And that would conclude my comments.
See no other questions. Thank you.
Thank you.
May it please the court, Assistant District Attorney Leslie Isherwood, appearing on behalf of the state. We will primarily be confining our argument today to the lesser included offense instruction issue, but obviously we'll take questions regarding any of the other issues that were raised and briefed. Standard of review for lesser included offense instructions, this court looks first at reviewability from a jurisdictional and preservation standpoint, whether it is legally appropriate, whether it's factually appropriate, and then if the court did err, harmless error under the standards set forth in Ward. And in this situation, because the instruction was requested, it would be whether there's a reasonable probability of a different outcome had the instruction requested been issued. From the first step, the reviewability analysis, the instruction was requested in the defense instruction packet. It was also renewed during the instructions conference, so the reviewability component of the analysis is satisfied. With respect to whether it is legally appropriate, it remains the state's position that under a strict elements analysis, that it is not a lesser included offense instruction, whether it is a lesser degree of homicide. It would be the state's position that it does not fall within the homicide spectrum, that there is a conceptual difference All other instances of homicide contemplates a victim who does not participate or intend to die, basically. And the difference here would be the counter, that when committing suicide, the victim specifically does intend to die. It is inherently separated by the interpretation of this statute that if the defendant commits the principal act that results in the death, then it becomes murder. But where the intent lies with the individual taking their own life, it conceptually distinguishes it from homicide. To the extent this court is persuaded that it does constitute a lesser included offense, the instruction was not appropriate because from a factual standpoint, it wasn't warranted in this case. A defendant who commits the principal act that results in the death is not entitled to the instruction. Here, the record will bear out that the defendant was leading the ship or steering the ship leading up to Trish's death. The defendant told E.H. 2 weeks prior to the death that it was Trish's time to go. On the day of, the defendant told E.H. that it's time. At the time of the murder, E.H. heard Trish shriek, followed by a splash, and then moments later the defendant came in with wet arms and out of breath, which would be, from the state's position, a circumstantial indicator that a struggle had occurred. Additionally, the second coroner that analyzed the evidence testified that Trish had bruises on the sides of her head that were indicative of being held underwater, or that they were conducive to the size of fingers that she had been held underwater. To warrant the instruction, the evidence would have to show that the defendant merely provided the pool or otherwise drove her to the location where there was a body of water where she could take her own life, and that is not this case. The defendant wants to rely on statements from Trish that she consented to this, that she was a party to this. But it would be the state's position that that is, in fact, questionable consent, because Trish also believed that she really wasn't going to go, that she was going to come back better, and that the defendant could somehow reach into purgatory and bring her back, thereby indicating that that's not necessarily her position, that she is in fact going to die, that this is a permanent state.
She was aware, though, that she was chosen, that she would be next. I mean, she was aware of that. She discussed it with numerous people, didn't she?
She discussed it with E.H. She had said, don't worry, I'm aware that this is going to happen, but she also said, I'm going to be back. And the physical evidence doesn't support the fact that she is the one that took her life. And in order for the defendant to be entitled to this instruction, Trish would have to be the one to take her life, and that is not what is demonstrated through the facts of this case. Therefore, the defendant was not entitled to this instruction. In the event that the court did err, was there a reasonable probability that the jury would have returned a different verdict? And it still would be the state's position that that same evidence that indicates he's not entitled to the instruction is an indication that the jury would not have found that lesser offense when the evidence shows that he held her underwater, that there was evidence of a struggle, that she drowned essentially in the shallow end of the pool, that the jury would not have returned a verdict for assisted suicide.
And that was the conclusion of the pathologist who testified at trial, not the coroner at the time.
Correct. The coroner at the time testified, she didn't testify that you can't commit suicide
Okay,
by
I thought
drowning.
that was softer than it was represented.
Right. She said there would have been somebody that had placed heavy blocks on their feet and committed
Virginia
suicide. She
Woolf.
just said it's very rare because the way that the human body is constructed, there's a natural defense mechanism that makes it very, very difficult to commit suicide by drowning.
But the bruises on the arms, for example, weren't spotted at the time of the event?
There were bruises on her skull.
Okay.
The
I thought
arms
there
were-
head wounds.
There was a head wound, and the paramedic that had testified when he extracted her from the water that he had bumped her head,
Right.
but that wound was distinctly different from the two that were on the sides of her head.
Okay, but
As-
then there were some bruises on her arms?
I don't recall that
Oh,
there were
sorry.
bruises on her.
Okay, I thought I heard a reference to that.
Yeah.
Okay.
I mentioned his wet arms when he
Okay.
left, but I don't recall, the record will speak for itself, but I don't recall there being bruises on her arms. If there are no other questions with respect to that issue, I would briefly touch upon the hearsay issue, and basically what is at issue with that was Detective Goodwin's testimony. This court reviews that claim from an abuse of discretion standpoint. The detective provided the summary for the jury. He was the third witness called by the state. He was the lead detective in this case, and his purpose in being called as a witness was to give the jury an overview of this decade nearly long investigation. It started in 2003 and ended around 2011. He became involved in 2003. The evidence with respect to the obituary concerning Mona Griffith, we have to look at everything in its proper context. That testimony was merely the detective identifying for the jury at what point in the investigation the defendant's name actually emerged as being involved. Everything at that point, all the investigation he had done into the residence brought up other names, but nothing had linked him to that yet. So this testimony was not offered to establish that the defendant had a wife or whomever that was killed in this plane crash. It was merely to establish it was at this point in time that the defendant's name emerged as being connected to this residence. The second instance regarding the hearsay was regarding that point when Detective Goodwin was asked whether he inquired into Brian's cause of death. Again, not for the truth of the matter asserted. The detective wasn't testifying that he investigated and found that Brian was killed under a car that had fallen on him. The point was that this was another death that had occurred that had resulted in the distribution of proceeds. So again, not truth of the matter asserted. It was the next piece of the investigation that started in 2003. Brian's death occurs in 2006 while the investigation is ongoing. So at that point, it's just, again, another area for the jury to follow with the progression of the investigation.
Didn't most of this, throughout the trial, most of the evidence that's being objected to as hearsay was corroborated by different testimony and evidence that was presented throughout
Yes.
the trial? Almost all of it was, I think.
Yes, but basically, if you look at it as a hand, this is Detective Goodwin and he testifies to these pieces, then ultimately piece A, B, C, and D, all of those individuals are called to testify. And that is further corroborated or further evidenced by the fact that when you read the extensive closing argument presented by the state, Detective Goodwin was not where this case rises and falls. That summary referenced what EH had to testify to, what KL had to testify to, what SH had to testify to, what the car dealers, what they testified to, the insurance agents, what they testified to. So Detective Goodwin gave the jury a summary. There was this extensive investigation, and then this is what the evidence is going to show you. And as the trial played out, that is what the evidence showed. That is where the evidence was introduced.
Could I point your attention to I think it's the third or fourth issue, which has to do with the limiting instructions?
Yes.
And instruction 7, I think, has to do with the limiting instruction on how you may consider some of the prior acts based upon motive, intent, plan, knowledge, and propensity. And then instruction 8 talks about evidence admitted related to the deaths of Mona Griffith, Lindsay Griffith, and the others, and may be considered solely to explain the relationship of the parties and the state of mind. Does there need to be a distinction in those two instructions on what particular charges instruction 7 is based on? I mean, it kind of says that are crimes of a sexual nature, but it doesn't specifically limit it. And the problem with that is then you can have propensity considered for other crimes that are not of a sexual nature or the indecent liberties. You see what I'm saying?
I do see what you're saying.
Okay, so explain to me how the jury would consider or not consider propensity in the other crimes where propensity is not permitted.
Well, first of all, one thing I would say is I think this case is a little bit anomalous because the limiting instruction was given. And a limiting instruction with 6455D evidence typically is not required. So I don't know how often that potential for confusion would be raised, to the extent that confusion exists. Further, I think the jury is presumed to follow the instructions. Propensity is distinctly absent from the second limiting instruction. Also, those instructions are specifically keyed to the nature of the evidence that they are, permitted to use it for. When we look at the specificity of the instruction, when we go with the premise that the jury is presumed to follow the instruction, when it's written in understandable, typical language, I think that a distinction does not necessarily need to be
So you think it's
drawn.
sufficiently specific, tending to prove that the defendant committed crimes of a sexual nature, that is sufficiently specific to those particular crimes?
Yes.
Okay.
When it, yes. Because I think when you view it with an eye towards the evidence that was admitted at trial, what that is referring to, I think viewing it in its entirety, the jury was properly instructed. If there are no further questions, the state would respectfully request that the defendant's convictions be affirmed and the decision of the district court be upheld.
Counsel, I do have one question. If I could take you back to the lesser included issue and ask really a pretty theoretical question. Is there any, in your view, is there any legal difference between 5109B1 and B2? Is there any legal difference between a lesser degree of the same crime and a crime that is lesser because it meets the elements test? I mean, presumably there is a difference because that's what the legislature said.
Right.
But I'm struggling to conceptualize what that difference is.
I'm not really sure how to answer that question.
Well, we do have voluntary manslaughter has additional elements that are not contained in first degree. So, I mean, reckless is not an intentional killing. So we do have lesser degrees that we've determined that do not fit the elements test. don't
But
we?
they're driven by the nature of the offense, that they're driven by the similarity of the offenses, I guess, so they would be a body of homicide.
But if we look
Cases.
at the level of culpability as defined by intent, all of those lesser degrees of intent are subsumed within the definition of the elements of first degree murder, aren't they?
Well, sure, but if you're looking at this case specifically, you're talking about intent lying in a different place.
I understand. I'm asking a question that's broader than this case.
Sure.
And I appreciate your struggle to answer the question because I struggle with it as well.
I guess I would just say that they are permitted to coexist because there are those crimes that are of a similar nature versus those crimes that bear similar elements. Given additional time, I could probably give you a more well thought out answer.
Would you like an extra 30 seconds?
I'd like an extra 30 days. Can I do that?
All right. Any more questions? Thank you, counsel.
No waiver rebuttal unless there are questions.
Any questions, counsel? I see none. Thank you.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.